Appeals Division 1 is now in session.
Good morning. Thank you. Please be seated. Thank you for your courtesy. This is the time set for oral argument in our case entitled Newman versus Select Specialty Hospital, Arizona, etc. Cause number 1 CA CV130665. I see that we are all signed in here, which is good. And as you know, we have reviewed the issues, your arguments. We've conferenced the case. We've talked about the various issues, and we're ready for your argument. And if you want to save a little time, each of you at the end, since there's an appeal and another appeal. I'm not sure which one of you is the appellant versus the cross-appellant, because I guess you filed on the same day.
I think we did, yes.
And so probably neither notice says notice of cross-appeal.
Lo and behold.
They probably just both say notice of appeal. So anyway, we'll give you both the option of reserving some rebuttal. And you may feel free in your first part to go into their issue if you want, and vice versa. But you don't have to.
May I ask, for purposes of our pleadings, we show Select Specialty Hospital, Arizona as the appellant. Does that offend anything in this case? No?
I don't believe so, Your Honor.
Thank you. If you would then.
Well, we'll find another way to offend you.
And we may tinker with those titles here too.
Good morning, everyone, Your Honors. My name is Scott Boehm. I am appellate counsel for plaintiff Ethan Newman today. With me, by the way, is Melanie Bossi, trial counsel for plaintiff, who created the record in this case. So hopefully that's a good thing for us. Between the two of us, Select and the plaintiff, we've got 4 issues dealing with the results of the trial and post-trial proceedings here. The significance of them, I think, is in the order that we briefed them. But I'd like to, if we have time, get to all 4 of them. The first one being a prima facie evidence for punitive damages. Second, what does costs of suit mean under APSA? The third one, which is the defendant's issue, is which version of APSA applies for attorney's fees. And if you go with them on that, then our last issue becomes moot, because that deals with the trial court's assessment of the attorney's fees under the version of the statute that was applicable in 2008-2009. Beginning with punitive damages, and if you want me to backtrack on any of these or shift somewhere else, just please jump in.
Punitives is a good place to start.
The court, I think everyone agrees, conducts de novo review of the JMAL on punitive damages under the well-settled standard that the court recited, and we talked about it quite a bit in our brief. Most recently in the McBride versus Kaikeffer case from a couple of years ago. The most significant issues or aspects, I think, for our purposes today, and it's something that you talked about in the immediately preceding argument, is that the evidence gets viewed in our favor as the losing party, and there's no weighing of the evidence, and the inferences are viewed in our favor, because all of those types of issues are jury questions. Now obviously, I'm not going to have time to march you through all of the facts that Melanie so ably put on for punitive damages and for liability. I mean, the evidence for punies was the same as the evidence for the underlying abuse and neglect. So the motion for summary judgment initially was denied, but after the conclusion of the evidence, the JMAL was granted in their favor on punies, with the trial court saying, and I know it's not really with a de novo standard, it really doesn't matter what the trial judge said, but I think it's important here.
Well, we're kind of interested in what went on at trial.
Well, yeah, and I think it's important here because the trial judge made a comment that he didn't have anyone saying that this patient was ignored in the bed. And I'll give you the exact quote.
Yeah, we might be interested in your comments on, well, we would be interested in your comments on whether there has to be something more for punitive damages, or is it enough to constitute conscious disregard of a known substantial risk that this man was not turned as he needed to be for long periods of time? Is that enough for punitives?
I think it is. I think there's, and I hate, this is a terrible answer to your question. The answer is yes to both. I mean, punitive damages require a heightened standard of proof. Yes. You have to have clear and convincing evidence, and in our situation, we have the conscious disregard standard. Now, we're not talking intentional
conduct. Have to have evil
conduct.
mind, but our cases say the evil mind can come from a conscious disregard.
Yeah, exactly.
But it has to be a conscious disregard, not a careless disregard.
And that is, I think, the significance of Mel's trial presentation here. And I hate to pat her on the back here, but she's one of the best and most experienced elder abuse lawyers in the States. She's done this lots and lots of times. She knows how to put on a case. So what I think is significant about that in this case is, and I'll just kind of click through these things in my mind that she did, and they're all itemized in detail in the brief, and the defendants don't challenge anything because it is what it is. But the touchstones of the things and the evidence that she presented to the jury here were, one, the standard of care, what they needed to do and why they needed to do it. All of their employees, not only by their policies manual, but also by the standard of care. And it wasn't, the turning was a big thing because this was, keep in mind, this was probably more so in this case than a typical 100-pound fading away 90-year-old woman. This was a 6'6", 280-pound kid who was in a motorcycle wreck. So turning, I think, became even more important. But it wasn't just turning. It was the failure to follow the doctor's orders. It was the failure to keep him clean, and it was the failure to give any of the initially critic aid treatment and then eventually the Aquacel treatment. So it was a series of things.
Was it the evidence that pretty much all the hospital employees who were involved knew that such patients had to be turned every few hours?
That's exactly, that was my next point. So not only did she cover what they needed to do, but, and this is probably the key, I think, to the punitive damages aspect of this case and most elder abuse cases, is they knew not only what they had to do, but why they had to do it. And witness after witness after witness, which were employees of theirs, in addition to our experts, of course, said, if you don't turn them, this is what's going to happen. And Mel went the extra mile and said, did you know this was going to happen? And the answer, and sometimes I quote it probably too much for you, but they all said, yeah, we knew this was going to happen.
Does the record reveal why they didn't do it?
Yeah, and I think, yes, it does. And I think you probably have to, this is possibly a area where you have to get into the inference, but the inference is, and it's, pretty obvious, I think. I mean, it's not a big leap of faith here to get to this inference, is they had only a 5-to-1 ratio of staff to patients. And the nursing
patients to one staff.
Five patients. Yeah, okay. One patient.
I was going to say otherwise.
There are people running all over here. Yeah, you're right. Sorry, I'm backwards on that. And you probably, again, taking the size of Ethan here, you probably need 2 people to turn over a 280-pound kid. The nursing home knew that they knew, and nursing facility, I got panned for calling it a nursing facility, but that's what it was. The nursing facility knew that they didn't have enough people to prevent these bed sores, to do regular turning, because they were having meetings on this. And the meetings and this was covered again in the evidence with some of the employees, that the specific meetings were, hey people, you're not turning these people enough, and we're getting an inordinate amount of bed sores. Now keep in mind, when Ethan came to the nursing facility, he had a small stage 2. And over the first 12 days, virtually nothing was done. He's just kind of a very big lump in the bed. And there was no turning of him at all, no giving of the critic aid. And again, for Judge Gallen, to get back to your question, the significance for punitive damages purposes is the people knew what was going to happen if they didn't follow through with what they were required to do. And not only that, they knew that in fact was happening. If they didn't know for the first 12 days when nothing was done, New Year's Eve seems to be a big time here, and I don't think we can overlook the fact that this was over the Christmas holidays, and that may or may not explain why this treatment wasn't done. We're talking about pie and donuts in the last oral argument. Maybe there was pie and donuts on the floor here. That is not an excuse. The reality is that on December 31st, they found out that this little red spot had turned into this gaping hole. And nothing changed after that. So they knew that what we had not done for the first 12 days he's there had caused this problem. And they continued to do nothing for the next 8 days until he finally had to go to another hospital because this thing was just, they weren't treating it. And it wasn't only based on, the defendant's argument, of course, is that this was, we just bad record keeping. We really did all these things, but we forgot to write it down. Well, that belies their evidence that in all medical cases, Judge Gelman, I know you've got some experience. The other two of you were trial judges. You've done these things before. The evidence is that if it's not down, it wasn't done. And it's not an excuse that, well, we did it and we just forgot to write it down. And we know that didn't happen here for a couple reasons, too, because if that was true, what the hell happened to this poor guy's butt? Because all of a sudden he's got this huge hole there. And of course, ultimately the jury didn't buy that because on this same evidence, although punities were knocked out by JMO, they returned the compensatory damages verdict of $250 for the exact same conduct. Hopefully that answers your question. The reality is ultimately, based on the evidence, that they knew what was going to happen, they knew what they had to do, they knew they weren't doing it, they knew what was in fact happening not only to the general population of the place, but also to Ethan specifically, and they kept on doing it, which is the second part of the conscious disregard.
Is it more than even gross negligence? If it's just gross negligence, I don't think there's penalties.
This was not. This was much worse. I've been doing appeals in nursing home cases for a lot of years, more years than I like to admit. This was as bad as it gets. And Melanie put on the case for a couple of weeks, as bad as it gets. And none of it was, their only explanation was we forgot to write it down.
Counsel, typically when we think about punitive damages, I think the old standard used to be an evil hand guided by an evil mind, so that there's the wrongful act guided by a wrongful intent. I don't hear that here. I hear that they did this thing, they did it, let's just assume it was incompetent, it was below the standard of care, it was grossly negligent. Let's assume all that stuff. Can you show me that? Can you show me that evil mind, that intent to cause harm? Or
there is the rub right there. I don't mean to point at you, but that is.
Yeah,
I know. I'm sorry about that. That is the rub. It's not an intent. Evil hand guided by an evil mind goes back to Rawlings and Lentz, come back in 86, 87. Since then, we've had a panoply of cases explaining what the heck that means, because it sounds pretty bad. It sounds like intent. But it's not intent. It is a conscious pursuit of a course of conduct, knowing that it created a substantial risk of significant harm to others. This, I'm quoting from this court's opinion in Quintero. Defendant's conduct need not be outrageous in order for plaintiff to recover, but they must continue their actions despite the inevitable or highly probable harm that will follow. Now that's here in spades, because not only was it likely to happen, it was happening, and they knew it happened, and they kept doing the same thing, which in effect was nothing for 21 days. Our expert told the jury, and accurately based on the evidence of the case, that they essentially left this guy there for 21 days until this hole got there. And they knew it was happening. It wasn't a situation where they're acting in ignorance. And this is not a situation like in the prior case where we don't know what happened. We know exactly what happened. We heard about it at trial for 2 weeks.
Well, we don't have to draw the conclusion of what kind of behavior this is, I don't think. We're just evaluating whether there's evidence from which the jury could conclude there's this conscious disregard, which the cases seem to say substitutes or constitutes the evil mind.
Yeah, you're right on 2 things. Well, but I'll go even further. They don't seem to say that.
The first time today, but go on.
No. But they don't seem to say that. They say that. That is the definition of what evil hand guided by an evil mind is. It's an alternative test. And every time I've argued this before this court and others, defendants always want to bring up the intent part of it. There's 2 prongs here. The other prong is the conscious disregard. Sometimes you might have an intent. If it was a shooting case or maybe a drunk driver case, something like that. But in almost all other punitive damages cases, it's the conscious disregard that gets you there. And the jury gets to, and this is something that I covered, probably way too much in my brief, they get to draw that conclusion. They get to make the inference based upon the balancing of the evidence. And it's not, you don't need direct evidence, which the trial court seemed to think here, and of course he was urged in that direction by the defendant. But circumstantial evidence and inferences based on circumstantial evidence can get the jury over that hump. And of course it wasn't given that opportunity here, which is why we're all here. I usually don't like string citations, and I'm getting down to 4 minutes, so I'm going to sit down and shut up here in a minute, but I do want to point this out. In my brief, and I'm sure you've all read it, there's one section that talks about all of the cases that have okayed a jury question based on circumstantial evidence and inferences based upon it. None of those cases are APSA cases. They're all, bad faith and drunk driving and blah, 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 blah. But none of them APSA. We've never, even though we've had punies in this type of issue and other APSA cases, winning and losing it, we just don't have a published opinion saying what kind of facts you need to get over the hump.
They might give you one.
Well, that's what I'm hoping for. So I've got almost 4 minutes left, so I'll shut up and wait till I get my chance to come back. Thank you very much.
Okay, thank you, Mr. Boehm. Mr. Meyer? I can't promise you'll like it if we give you one.
Pays your money, it takes your
But you might. I don't know.
Thank you, Your Honors. My name is Kevin Meyer from the firm of Broning, Oberg, Woods, and Wilson, representing Select. The Superior Court was correct in granting JMOL on the issue of punitive damages because no reasonable jury, based on the standards of evidence required and the elements of punitive damages, could have found that the facts of this case supported a claim for punitive damages.
And wasn't the court concerned specifically about the evil mind component, though, as opposed to conscious disregard?
Yes, Your Honor, although I think with respect to what Judge Gemmel was asking earlier about the something more, I think that's all wrapped up together. I think the court was looking for something that's going to that would transform the allegations in the record in this case beyond just mere negligence, which the court conceded very well could be the case, and obviously the jury in this case found negligence. But the court spent several pages in that November 15th transcript talking about, I can see negligence, I really don't even see gross negligence, and you have to do better than that. What's the something more? What gets you over that hump? Now, whether you call that an evil mind or whether you call that a conscious disregard of a substantial risk of harm, I'm not sure it really matters, because what the court said in this case was, I think that the only reasonable conclusion a jury could draw was that perhaps there was negligence in this case, but I don't see evidence, clear and convincing evidence, sufficient to transform this into a punitive damages case.
I think we're struggling in these cases from time to time, and perhaps in this one, to understand the legal difference between carelessness and consciousness. Maybe I'm oversimplifying, but I would certainly agree with tossing out the punitive damages if all we have looks like carelessness. And that could be 1 or 2 or 3 times, or once in if the patient is supposed to be turned 4 times a day, let's say, I'm not sure what the number would be, but let's say 4 times a day, and he's turned 3 times a day, well, maybe that's carelessness. But this sounds worse than that.
Plaintiffs have talked about the fact that there isn't any APSA case law on this point. What constitutes punitive damages in an elder or protected person abuse case?
Well,
I'm sorry.
Excuse me for interrupting, but I think you both cited, as I recall, that the statute says.
It's the same standard for any other case. You're right. Although the context sometimes helps, and obviously the examples we have are usually in product liability cases or in other cases of personal conduct. So plaintiffs often cite these Florida cases that they talk about. One of the Florida cases talks about the fact that the nursing home in that situation was actually under investigation by the state and had been warned by the state, and there were reports of these problems, and continue to have the staffing problems. That might be a better case for a conscious disregard. But when you have a situation in which a plaintiff clearly is receiving care, whether that care is optimal and efficient is another issue. But when you have a case in which a plaintiff is receiving care, and the nursing home is working on addressing issues as to the efficiency of their care and whether things need to happen, I don't think that's a conscious disregard. It may not be a well-executed plan ultimately, and there are other medical issues that might come into play, but that's not a conscious disregard. That's not a situation in which a person knows ahead of time that there's a problem, has been warned, especially by trained state investigators, and simply chooses not to address the issue.
What happens though, counsel, what happens though when it is brought to their attention? They recognize the existence, they alter the medication to deal with the circumstance that's arisen, but then they don't give them the medication. What do you do with that?
I think it depends on a case-by-case basis. But I think what you have in this situation is a case in which caregivers were trying to work on a situation. There's obviously some disputed testimony as to what stage the wound was in and how much assistance could actually be given at this facility. But the point is, when they recognize it themselves and are trying to solve the problem, I don't know how that's a conscious disregard of the risk of harm. Plaintiffs made a big point about saying that everyone said, well, we knew exactly what was going to happen. I mean, in a medical sense, sure, you understand that if this treatment and these symptoms progress and get to this stage, then obviously there's going to be a result. But I don't think anyone said we gave up on them. I don't think anyone said that
Correct me if I'm wrong then, because my understanding was that there were a lot of nurses involved, nursing staff people. A doctor came in and looked at it, I believe. A doctor changes the medication to something that I got the impression was a more aggressive sort of a handling of this. They prescribe it, they get it, they put it on once or twice, and then stop. Is that not the case?
Even under those facts, Your Honor, I think that's a call of medical judgment and a question of whether the medical professionals are acting under the standard of care. And that may have been violated, but there's no one saying here, we knew that we had to do this, we knew that this was the only result and that this was the only type of care that could be given, and we just chose not to because we needed to save money or we needed to
I don't particularly care about the reasoning. If the file for the patient says give him this 3 times a day, and they give it to him twice, don't give him the 3rd time that day, and then don't give it anymore after that, is that not a conscious disregard of the orders of the doctor?
I think that nurses don't follow doctor's orders sometimes. And I don't think that in every instance that failure to follow the doctor's orders constitutes a conscious disregard. I think that might be medical negligence. But there may be issues of judgment that are being called into play, and that's what we have with the professional negligence claim. We're talking about the individual types of judgment decisions that are being made. And again, while that may lead to a result, and while that may be a tragic result, that's not a conscious disregard of a substantial risk of harm if there are reasons.
What is a conscious disregard then?
I think in the medical malpractice stage, I think certainly a very common example or one that leaps to mind is the idea of the surgeon who goes in drunk. The surgeon knows that his or her inebriation is going to prevent him or her from actually performing the surgery well. And that's the risk of harm is clear, and that's a conscious disregard ahead of
May
time.
not even recognize it in his drunken state.
But wouldn't, it would in fact, regardless of the doctor, be then on the hospital to protect its patients from that. And it's happened more than once, and you've got a conscious disregard.
Yes, I think if it has happened more than once, and there's no instance in which a doctor can say, in my medical judgment, it was wise and prudent of me to drink before having surgery, especially when I drank to the point of excess and inebriation.
But back to our case, if I could, and get your help on this. Let's say that the trial judge, or one or more of us, was thinking that this could have just all been carelessness. But there might be some conscious disregard here, depending on how the facts are interpreted and the inferences drawn. Therefore, because a jury could draw the inference of conscious disregard, I have to send it to the jury.
Again, I think the clear and convincing evidence standard comes into play, and approximately maybe 75% surety. I don't think that on this record you could say the people who were meeting, who were trying to solve a problem, who knew there was a problem and were trying to work with it, are consciously disregarding that problem and are acting with an evil mind at that point.
I hate to confess out loud that I've never but I'll do it anyway. I've never fully understood how the clear and convincing, as opposed to a preponderance, or 51%. How does the clear? I'm not sure how a trial judge or this court is supposed to change the analysis for clear and convincing. Ultimately, the burden of proof is higher, but I've never been totally sure that the burden to get to the jury was higher. But I think you're suggesting that.
I think I am. I'm suggesting that there is a clear and convincing standard for all aspects of punitive damages. In fact, including whether the conduct that's described as punitive is a direct and proximate cause of the actual injury.
As I recall, I think Judge Gama referenced the clear and convincing in making his ruling.
Yes, and I think in terms of trying to apply it, because the trial court said, I don't even know if you reached the standard of grossly negligent. And again, that's that intermediary stage, which might be akin to a clear and convincing 75%. Because I can't even see that you get to that point. I don't know how you even get to the next stage, which is the evil mind. And because of that, if that's a reasonable analysis, and we submit that it is, then that's a reason for granting the JMOL on punitive damages in this case.
Wouldn't a better kind of rule of thumb would let the jury decide, and if they do in fact then grant, then you can correct it by setting it aside, and the issue then is, then we get everything. We get the jury's analysis, because then there's the question about conscious disregard and whether it's 66 2/3% or 75% or whatever it might be. Gets all resolved in the wash.
I think that's probably best left to the individual judge's discretion. The courts hear the evidence and have a sense of how these cases proceed. And I think that certainly some judges might be inclined to do that, Your Honor. But I think that the rule certainly allows for it, and I think it's an assessment of the standard.
I think you were about to go to another subject.
I sure was, Your Honor.
Before I waylaid you. Or delayed you.
No, thank you. I appreciate the court's question. Are there any other questions on this point? I probably wouldn't come back to it in rebuttal.
I'd like to talk more, but maybe it's good to move to the next issue.
The Superior Court committed legal error in granting attorney's fees under the APSA statute to the plaintiff, because at the time plaintiffs would have been eligible for that attorney's fees, the statute no longer awarded attorney's fees. And because of that, we ask this court to reverse the award of attorney's fees in favor of the plaintiff. We think that the statute in this case is unique because it talks about after a determination of liability. And then that's the phrase that's remained through all the different changes of the statute, and that's what happened in this case. We would submit that there was not a vested right to attorney's fees in this case until such time as there was a determination of liability.
What if we just toyed with the language and said, well, there was a vested right in 2009 when he was in the hospital in your client's facility. There was a vested right to attorney's fees at that time upon establishment of liability. I mean,
I guess I don't think that fits with
words almost.
Well, words have meanings, and we have to be careful on how we construe them. I think the plain reading of the statute indicates that that's the trigger, that's the time at which the attorney's fee award or the eligibility for an award of attorney's fees is vested. I think it's different than the Abram case, because in the Abram case, you're dealing with that statute relating to employment cases 23-355. That statute actually put attorney's fees as an element of damages. In the event that your cause of action is successful, you get these damages. I think that's a distinction in this case, because in this case, we're not talking about the nature of the APSA claim. We're not saying that the APSA claim had not vested and that the plaintiff had a right to bring the APSA claim. We're just saying that the nature of the attorney's fees is different, and that's a separate right, and that didn't vest until there was a determination. And we think it's akin to the issue of post-judgment interest. You might have a right to post-judgment interest, but you don't necessarily have a right to the rate at which post-judgment interest is awarded. We've seen a lot of cases recently in that area. So you have an award of attorney's fee, or excuse me, of post-judgment interest, and that may change depending on what the rate of interest is at the time that you become eligible. And of course, you don't become eligible for post-judgment interest until such time as you actually have a judgment. So
it strikes me that we're making a distinction without a difference. You're never entitled to attorney's fees until there's determination of liability, right?
I think under the attorney's fee, or under the employment statute, that was.
You can lose the case and get awarded attorney's fees?
No, I'm sorry. Of course not.
Family law.
In family law, you can.
That all depends on who you call the loser in that case. But my question for you is this. In 98% of the cases that come before any court, at the culmination of the proceedings regarding the underlying substantive issues that bring the matter before the court, then a decision must be made about whether or not attorney's fees are going to be awarded, correct?
Yes.
How is this different from that? And if you tell me until liability is established, okay, until the contract was breached, until the event occurred, I mean, you couldn't get the attorney's fees until you knew there was a basis for the attorney's fees.
Well, I think that's why attorney's fees are different than a cause of action in terms of the substantive right. The right to bring a cause of action vests at the time of the injury, and it doesn't matter whether you're eventually able to later prove liability. But attorney's fees aren't simply as protected as a cause of action might be, because you actually have to have that determination of liability regardless of the form of the case.
But how is there a gain from saying that we're going to distinguish that in any fashion, where in both cases you're delaying the attorney's fees event until the liability is established, and the only reason it serves a benefit here is because the statute changed. If the statute had not changed, there'd be no question about it, but there's a gain here, there's a benefit from the fact that in the subsequent structure of the statute there's no more attorney's fees allowed. But no one anticipated that when they passed the statute and said, we're going to repeal this down the road, and when we do, we don't want people to, I mean, isn't that kind of a weird way to look at an attorney's fees application?
I would submit respectfully that the legislator giveth and the legislature taketh away. And what you have in this case is the legislature initially passed a statute that awarded attorney's fees, and you could get attorney's fees up to 2 times the compensatory damages. And then they came back and they amended and they said, change our mind, sorry, you can only get attorney's fees up to compensatory damages 1 time. And then they came back and said, you know what, scratch that, you guys don't get attorney's fees. Attorney's fees aren't protected in common law, and the legislature, if it wants to, can take that away. And all we're saying is that your right to that is vested at the time that there is a liability determination if that's written into the plain language of the statute, which in this case it is.
Would it make more sense if the amendments to the statute said, and we're making this retroactive to whatever the date, so that includes and that clarifies? Because that didn't seem to occur.
No, it didn't. But I think the the legislature makes its changes and leaves to the court the administrative rules on how to apply that. And again, because of this really doesn't get down to the retroactivity aspect of it, because what it comes down to is when the right vests, and that's our argument. Unless the court has further questions, I'd like to reserve the remainder 3 minutes.
Let's do that, and let Jason. How do you feel about adding 2 minutes to each side? Can you do that for us? You need to stop Mr. Meyer's time from running also. He's still counting there.
Okay. You can certainly tell Judge Gemmel's enjoying this one way or the other.
Well, we have a number of issues here.
We do.
Neither of you has a lot of time left, even at that.
Your Honors, I'd like to start off by revisiting the punitive damages aspect, because I think from your question, I think we still may be miscommunicating, which is obviously is my fault. To start with, and this is something that Judge Jones that you said. You said that the trial judge did not seem to be so worried about the conscious disregard aspect, but rather the evil mind aspect. There's no difference between the two. Okay. The conscious disregard is the definition of evil mind. So they're not, first you prove conscious disregard, and then you prove some higher mental intent of evil mind. If you prove conscious disregard, that is the mental element that you need for punity. That is what evil mind means. It means intentional, malicious conduct, but it also means conscious disregard, knowing that a substantial risk of significant harm is about to happen. So I just want to clarify that, because I obviously didn't the first time I was up here. Second thing, Judge Jones, your assessment of the facts are exactly right in terms of the Aquacel prescription on December 31 and them giving one and then stop it. But it actually is worse than that, because the same thing happened after he got there, because he showed up with a stage 2 sore. And there was a prescription for Criticade. And again, they didn't give him any for 8 days. And then they gave him a couple, and then they stopped again for the next 4. So this is not something that the disregard and the not doing what they were supposed to do did not just happen after they realized this was stage 3. This was going on from the get-go as to the drugs, as to following the doc's orders, but also from the get-go as to the turning every 2 hours, and also from the get-go as to keeping him clean, keeping the catheter clean, keeping the fecal matter out of this growing wound. All of that was from the get-go. They didn't just stop doing that after it got to stage 3, which is significant because, Judge Gemmel, you asked a question, why is this not just carelessness? And the answer to that is because it went on for 21 days. If they had just skipped a turn here, a turn there, if they did it 3 times, even if they skipped every other one and gave them every other treatment, medical treatment, this isn't that. They didn't just accidentally or carelessly do nothing for 21 days. And, I say nothing. They did a couple of things, but basically nothing. And in response to one of your gentlemen's questions, defense counsel said, well, the classic example of punitive damage is if the surgeon shows up drunk, but he actually does the surgery. I mean, these people were stone cold sober, supposedly, and didn't do nothing. Didn't do anything. Pardon my double negative there. But the reality is at least in the clearest example of punities, the guy actually does the stuff. And here they did nothing for 21 days. And that's what gets us over. Judge Portley, you asked the question of wouldn't it have been easier to let this go to the jury and then deal with it as post-trial? Does anyone have any doubt that if this would have gone to the jury on punitive damages, and if the jury would have assessed punitives in whatever amounts constitutionally permissible, and we were up here on, was it error to submit it? It's not even a close call. What could possibly be worse than not treating him for 21 days? It's just impossible for me to even fathom, short of some intentional harming the guy or something like that. But in terms of actual treatment or lack of treatment, nothing could be worse than what happened in this case, which is, and I think that's why it makes a perfect case for you to address this. I've got 57 seconds left, and I've got just one quick comment on the attorney's fees aspect. We obviously think the statute that was in effect at the time applies. And I will just point out, and I pointed this out in the brief, but I think it bears repeating, and this is something that the trial judge jumped on as well. If you go through the APSA statute, subsection G, which is the one right before the damages, talks about types of things that can be, orders that can be entered before determination of liability. And that includes restraining orders, TROs, performance bonds, receivers, stuff like that. And then the next section is after liability, and then you can do the damages and everything we've been talking about. So what our position is, and you may have said this if I was taking notes, but the trial court certainly did, is these are just timing mechanisms. This is what you can do beforehand, this is what you can do after. But the statute itself and his right to pursue his claim under the statute. And this is a part of his damages that were vested at the time. Now that also applies to the trial court's assessment of attorney's fees, which we didn't get to.
Vested at what time, counsel?
At the time his cause of action accrued.
Thank you.
Which is, he knew, obviously, this was not a discovery type issue. I mean, he knew right away.
And by that you mean when he was in the hospital?
Yeah. So, and there's no question of
I see your time's up.
I am out, and I could ramble all day.
We'll give you a 15-second paragraph if you want.
You know what? I don't know that I could say anything that you haven't heard me say twice already. So thank you all very much.
And we have your briefing, of course. Thank you, Mr. Bain. Mr. Meyer?
Thank you, Your Honor. With respect to the punitive damages issue, counsel mentioned that in the clearest example of punitive damages, at least the surgeon did his job. I guess I took it without having to say so that in my example, the surgeon cuts a vein and nicks an organ and doesn't really help the situation at all. There can be a question as to whether care was appropriate in this case and whether that was actually helpful. But what you do have is medical professionals working at a job trying to get things done. One of the statements from one of the professionals had to do with the idea that with respect to nursing or hospital issues, understaffing is always an issue at every situation that you encounter, at every hospital that this person had worked at. I would submit that every hospital is not liable for punitive damages simply because staffing elements could be better. Again, we also have a number of facts set forth in the brief in response. You have situations in which wound care nurses are attending to this person. Doctors are giving judgments. There's a question as to whether there's good granulation with respect to the wound, which would suggest progress. All of that is medical judgment, and that judgment may be wrong, and that judgment may be incorrect, and the actions may be negligent, and they may even be gross negligent. But to the extent that medical judgment's being used, that a patient is being cared for and attended to, and there's a question as to whether the prescribed treatment is efficient or being carried out, I submit that that is an issue of negligence, and at worst case, gross negligence. But the facts of this case don't rise to the issue of a conscious disregard.
Continuous, or at least consistent pattern of medical judgment, even if not more wise, takes it out of conscious disregard and punitive damage.
I mean, some people are going to be in the hospital or in a care facility for a long period of time, and so the length of time is not necessarily the issue. This isn't a case of 21 days of absolute disregard. This is a case of a person who got worse after coming to the facility with a serious wound.
But didn't they get worse? Because I guess I'm trying to track what you're saying. The doctor ordered something, and it's in the record, and they decided it was optional, and he got worse as a result?
I'm not saying they decided it's optional. I'm saying that in their judgment, they applied the treatment that they could. They followed the orders to the best that they could. That best may not have been good enough.
Oh, wait, you say to the extent they could. Are you saying they ran out of the medicine?
No, what I'm saying is,
They just didn't give it.
yes, but there are other factors that indicate that maybe he was getting better or he was okay. They're not just turning a blind eye to this person. They're checking on him. They're working with him. There are questions as to whether all personnel agree that the course of condition of the patient is the same. If that's the case, that's a question of medical judgment, and that's not a case of a conscious disregard. Again, to bring it back to the Florida case I was describing earlier, if you had a case in which a regulatory industry came in and told you your staffing levels are 15 to 1, that's just prima facie, per se, completely irresponsible, and you fail to correct that problem, and additional problems occur that are the same issues that got you under investigation in the first place, I think then you're starting to talk about a conscious disregard. But if you're working within a system and an environment in which you have people who are trained and people who are trying to respond to the problem, and they're maybe not getting it right, that's not a conscious disregard. That's a negligence when an injury results from that.
Okay, so hang on. I have a problem. I'm taken by ambulance to the hospital. They begin a process of treatment, but the standard is lower in regard to what I should expect if they just are working at it but just aren't quite getting it right. So I don't have a right to demand a higher level or to require a high level in order to properly treat my problem?
You get compensatory.
I would agree with Judge Gamble.
So it's determined based upon the effectiveness of the hospital's handling of the deficiency, not upon the need of the patient, the medical need of the patient.
If you look at those Florida cases, another case you're going to see is a place in which a nursing home knew that it had problems with staffing levels, and they grabbed a janitor to try to cover for head count. You don't have that in this case. This isn't a situation in which there's efforts to deceive or efforts to ignore a problem that has existed. What you have are medical professionals trying to resolve a problem and perhaps not getting it right. And when they don't, and an injury results, that's negligence, and that's what we had in this case. But it's not punitive damages.
Thank you both very much. We'll take the matter under advisement. It's good to see you both, Scott and Kevin, and Melanie. Nice to meet you. And this is a good case for us to present several issues for us to wrestle with. Thank you.